In a latest development in the Maharashtra political crisis, the Supreme Court today told the Election Commission of India that it should not decide upon the Eknath Shinde faction's plea to be recognized as the real Shiv Sena until the court decides on referring the matter to a 5-judge constitution bench. The Chief Justice of India leading the bench orally said that the decision on reference is likely to take place on Monday, that is August 8th. A bench comprising Chief Justice of India N.V. Ramana and Justices Krishna Murari and Himakali observed in the order that the Election Commission of India may grant a reasonable adjournment to the Uddhav Thackeray group to file their responses in view of the pendency of the matter in the Supreme Court. During the proceedings, the Election Commission of India took the stand that the disqualification proceedings under the 10th schedule of the Constitution operate in a different territory and that they do not affect the Commission's power to decide the claim of the rival faction for official recognition. Before proceeding to the arguments made in the court today, let us have a look at the events that led to the initiation of proceedings before the Supreme Court in the first place. In the wake of the political crisis in Maharashtra, rebel MLAs of the Shinde faction had received disqualification notices from the then Deputy Speaker for acting against the party whip while voting during the Member of Legislative Council elections in the state. The rebel MLAs then approached the Supreme Court against these disqualification notices. On June 27th, the Supreme Court granted interim relief to Shinde and his rebel group of MLAs by extending the time to file responses to the disqualification notices sent by the Deputy Speaker till July 12th. Subsequently, the court on June 29th also permitted the floor test to take place, which was called for by Governor Bhagat Singh Koshari. This led to the fall of the Thackeray government in Maharashtra, resulting in Eknath Shinde taking oath as the Chief Minister with the backing of the BJP, which is the single largest party in the House. In the meantime, the Thackeray-led faction filed various petitions before the Supreme Court, such as the challenge to the illegal summoning of the Assembly by the Governor of Maharashtra for conducting the floor test. Another petition challenged the order of the newly appointed Speaker removing Ajay Chaudhary and Sunil Prabhu respectively from the posts of leader as well as chief whip of the Shiv Sena party. On the other hand, the Shinde faction approached the Election Commission to decide which is the real Shiv Sena, the Shinde camp or the Thackeray camp, and their claim over the party's election symbol, the bow and the arrow. This prompted the Thackeray camp to move the Supreme Court, contending that the Election Commission should be restrained from deciding the Shinde camp's plea until the petition on the disqualification of the rebel MLAs is decided by the Supreme Court. Now, let us have a look at what arguments were made in the Supreme Court today. Appearing for the Shinde faction, Senior Advocate Hari Salve submitted that disqualification proceedings under the 10th schedule of the Constitution usually take several months, and thus in the meantime it should not mean that the Shinde faction of MLAs should be barred from attending the proceedings in the House. He emphasized that the anti-defection law cannot be made to appear as an anti-dissent law and that there is no illegality per se until and unless there is an express finding of disqualification. At this point, the Chief Justice of India inquired that if the bench agrees with him, then what will be the use of the party whip? The Chief Justice remarked further, and I quote, "We cannot totally ignore the political party. It will be a danger to democracy." In response, Salve argued that in the present case, there is nothing to show that the rebel MLAs have left the party. He also pointed out as to whether the decisions taken in the House and the votes given in the months preceding the decision on disqualification can be rendered illegal. On the other hand, Senior Advocate Kapil Sibal, appearing for the Uddhav group, argued that the claim raised by the Shinde faction before the Election Commission is based on the fact that they had the support of 40 MLAs out of the total of 50 MLAs. However, Sibal pointed out that if 40 of those MLAs of the Eknath Shinde faction are disqualified by their conduct due to the disqualification proceedings pending against them, then they can no more be considered to be the real Shiv Sena, which will result in their claim before the Election Commission also failing. He thus urged that the Election Commission should be restrained from deciding the Shinde camp's plea until the petition on the disqualification of the rebel MLAs is decided by the Supreme Court first. Appearing for the Election Commission, senior advocate Arvind Dattar argued that disqualification proceedings under the 10th schedule of the Constitution operate in a different territory altogether and will not interfere with the jurisdiction of the Election Commission, as the body is governed by the Representation of People's Act and the Election Symbols Order. He highlighted that disqualification proceedings under the 10th schedule can only affect the qualification with respect to one's membership of the legislature, and thus, even if a person is disqualified, it will not affect his membership of a political party, which is the only thing the Election Commission is concerned with. He thus underscored that the Election Commission's powers and the powers of the Speaker under the 10th schedule are not dependent, and thus the Election Commission's proceedings should not be interfered with. After hearing the submissions, the Chief Justice of India ordered the Election Commission to not take any precipitative action in the meantime. Thank you. I'm Aratrika Bhaumik reporting for LiveLaw.